the nation to determine whether a foreign adversary had interfered in the presidential election. As the acting Attorney General said at the time, the appointment was necessary in order for the American people to have full confidence in the outcome. My staff and I carried out this assignment with that critical objective in mind: to work quietly, thoroughly, and with integrity so that the public would have full confidence in the outcome. The order appointing me as special counsel directed our office to investigate Russian interference in the 2016 presidential election. This included investigating any links or coordination between the Russian government and individuals associated with the Trump campaign. It also included investigating efforts to interfere with or obstruct our investigation. Throughout the investigation, I continually stressed two things to the team that we had assembled. First, we needed to do our work as thoroughly as possible and as expeditiously as possible. It was in the public interest for our investigation to be complete, but not to last a day longer than was necessary. Second, the investigation needed to be conducted fairly and with absolute integrity. Our team would not leak or take other actions that could compromise the integrity of our work. All decisions were made based on the facts and the law. During the course of our investigation, we charged more than 30 defendants with committing federal crimes, including 12 officers of the Russian military. 7 defendants have been convicted or pled guilty. Certain of the charges we brought remain pending today. And for those matters, I stress that the indictments contain allegations, and every defendant is presumed innocent unless and until proven guilty. In addition to the criminal charges we brought, as required by Justice Department regulations, we submitted a confidential report to the Attorney General at the conclusion of our investigation. The report set forth the results of our work and the reasons for our charging and declination decisions. The Attorney General later made the report largely public. As you know, I made a few limited remarks about our report when we closed the special counsel's office in May of this year. But there are certain points that bear emphasis. First, our investigation found that the Russian government interfered in our election in sweeping and systematic fashion. Second, the investigation did not establish that members of the Trump campaign conspired with the Russian government in its election interference activities. We did not address collusion, which is not a legal term. Rather, we focused on whether the evidence was sufficient to charge any member of the campaign with taking part in a criminal conspiracy, and it was not. Third, our investigation of efforts to obstruct the investigation and lie to investigators was of critical importance. Obstruction of justice strikes at the core of the government's effort to find the truth and to hold wrongdoers accountable. Finally, as described in Volume 2 of our report, we investigated a series of actions by the President towards the investigation. Based on Justice Department policy and principles of fairness, we decided we would not make a determination as to whether the President committed a crime. That was our decision then, and it remains our decision today.
Bingo.
Let me say a further word about my appearance today. It is unusual for a prosecutor to testify about a criminal investigation. And given my role as a prosecutor, there are reasons why my testimony will necessarily be limited. First, public testimony could affect several ongoing matters. In some of these matters, court rules or judicial orders limit the disclosure of information to protect the fairness of the proceedings. And consistent with long-standing Justice Department policy, it would be inappropriate for me to comment in any way that could affect an ongoing matter. Second, the Justice Department has asserted privileges concerning investigative information and decisions, ongoing matters within the Justice Department, and deliberations within our office. These are Justice Department privileges that I will respect. The Department has released a letter discussing the restrictions on my testimony. I therefore will not be able to answer questions about certain areas that I know are of public interest. For example, I am unable to address questions about the initial opening of the FBI's Russia investigation, which occurred months before my appointment, or matters related to the so-called Steele dossier. These matters are subject of ongoing review by the department. Any questions on these topics should therefore be directed to the FBI or the Justice Department.
Jeez.
As I explained when we closed the special counsel's office in May, our report contains our findings and analysis and the reasons for the decisions we made. We conducted an extensive investigation over 2 years. In writing the report, we stated the results of our investigation with precision. We scrutinized every word. I do not intend to summarize or describe the results of our work in a different way in the course of my testimony today. As I said on May 29th, the report is my testimony, and I will stay within that text. And as I stated in May, I will not comment on the actions of the Attorney General or of Congress. I was appointed as a prosecutor, and I intend to adhere to that role and to the department standards that govern it. I'll be joined today by Deputy Special Counsel Aaron Zebley. Mr. Zebley has extensive experience as a federal prosecutor and at the FBI, where he served as my Chief of Staff. Mr. Zebley was responsible for the day-to-day oversight of the investigations conducted by our office. Now, I also want to again say thank you to the attorneys, the FBI agents, the analysts, the professional staff who helped us conduct this investigation in a fair and independent manner. These individuals who spent nearly 2 years of working on this matter were of the highest integrity. And let me say one more thing. Over the course of my career, I have seen a number of challenges to our democracy. The Russian government's effort to interfere in our election is among the most serious. And as I said on May 29th, this deserves the attention of every American. Thank you, Mr. Chairman.
Thank you. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Director Mueller, the President has repeatedly claimed that your report found there was no obstruction and that it completely and totally exonerated him. But that is not what your report said, is it?
Correct. It is not what the report said.
And now, reading from page 2 of volume 2 of your report that's on the screen, you wrote, quote, "If we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment," close quote. Now, does that say there was no obstruction?
No.
In fact, you are actually unable to conclude the President did not commit obstruction of justice. Is that correct?
Well, we, at the outset, determined that we, when it came to the President's culpability, we needed to go forward only after taking into account the OLC opinion that indicated that a president, sitting president, cannot be indicted.
So the report did not conclude that he did not commit obstruction of justice. Is that correct?
That is correct.
And what about total exoneration? Did you actually totally exonerate the President?
No.
Now, in fact, your report expressly states that it does not exonerate the President.
It does.
And your investigation actually found, quote, multiple acts by the President that were capable of exerting undue influence over law enforcement investigations, including the Russian interference and obstruction investigations. Is that correct?
Correct.
Now, Director Mueller, can you explain in plain terms what that finding means so the American people can understand it?
Well, the finding indicates that the president was not exculpated for the acts that he allegedly committed.
In fact, you were talking about incidents, quote, in which the president sought to use his official power outside of usual channels, unquote, to exert undue influence over your investigations. Is that right?
That's correct.
Now, am I correct that on page 7 of volume 2 of your report, you wrote, quote, the president became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the president engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation, close quote. So President Trump's efforts to exert undue influence over your investigation intensified after the president became aware that he personally was being investigated?
I stick with the language that you have in front of you,
Which
comes from page 7, volume 2.
Now, is it correct that if you concluded that the president committed the crime of obstruction, you could not publicly state that in your report or here today?
Can you repeat the question, sir?
Is it correct that if you had concluded that the president committed the crime of obstruction, you could not publicly state that in your report or here today?
Well, I would say the statement would be that you would not indict, and you would not indict because under the OLC opinion, a sitting president, cannot be indicted, be unconstitutional.
So you could not state that because of the OLC opinion, if that would have been your conclusion?
OLC opinion with some guide, yes.
But under DOJ, under Department of Justice policy, the president could be prosecuted for obstruction of justice crimes after he leaves office, is correct?
True.
Thank you. Did any senior White House official refuse a request to be interviewed by you and your team?
I don't believe so.
President?
Well, let me take that back. I would have to look at it, but I'm not certain that that was the case.
Did the president refuse a request to be interviewed by you and your team?
Yes.
Yes. And is it true that you tried for more than a year to secure an interview with the president?
Yes.
And is it true that you and your team advised the president's lawyer that, quote, an interview with the president is vital to our investigation, close quote?
Yes.
And is it true that you also, quote, stated that it is in the interest of the presidency and the public for an interview to take place, close quote?
Yes.
But the president still refused to sit for an interview by you or your team?
True. True.
And did you also ask him to provide written answers to questions on the 10 possible episodes of obstruction of justice crimes involving him?
Yes.
Did he provide any answers to a single question about whether he engaged in obstruction of justice crimes?
I would have to check on that. I'm not certain.
Director Mueller, we are grateful that you are here to explain your investigation and findings. Having reviewed your work, I believe anyone else would engage in the conduct described in your report would have been criminally prosecuted. Your work is vitally important to this committee and the American people because no one is above the law. I'll now recognize the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. And we're moving, I know, understanding, just reiterating the 5-minute rule. Mr. Mueller, I have several questions, many of which that you just answered will be questioned here in a moment, but I want to lay some foundation, so we'll go through these fairly quickly. I'll talk slowly. I'm said that I talk fast. I will talk slowly.
Thank you, sir.
In your press conference, you stated any testimony from your office would not go beyond our report. We chose these words carefully. The work speaks for itself. I would not provide information beyond that which is already public in any appearance before Congress. Do you stand by that statement?
Yes.
Since closing the special counsel's office in May of 2019, have you conducted any additional interviews or obtained any new information in your role as special counsel?
In the wake of the report?
Since the closing of the office in May of 2019.
And the question was,
have you conducted any new interviews and any new witnesses,
No.
anything? And you can confirm you're no longer special counsel, correct?
I am no longer special counsel.
At any time with the investigation, was your investigation curtailed or stopped or hindered?
No.
Were you or your team provided any questions by members of Congress of the majority ahead of your hearing today?
No.
Your report states that your investigative team included 19 lawyers and approximately 40 FBI agents and analysts and accountants. Are those numbers accurate?
Could you repeat that, please?
40 FBI agents, 19 lawyers, intelligence analysts, and forensic accountants. Are those numbers accurate? This was included in your report.
Generally, yes.
Is it also true that you issued over 2,800 subpoenas, executed nearly 500 search warrants, obtained more than 230 orders for communication records, and 50 pen registers?
That went a little fast for me.
Okay. In your report, I'll make this very simple. You did a lot of work, correct?
Yes, that I agree.
A lot of subpoenas, a lot of pen
A lot of
registers.
subpoenas. Yes.
Okay, we'll walk this really slow if we
A lot
need
of
to.
search warrants.
All right, a lot of search warrants, a lot of things. So you're very thorough.
The what?
In your opinion, very thorough. You listed this
Yes.
out in your
Yes.
report, correct?
Yes.
Thank you. Is it true the evidence gathered during your investigation, given the questions that you have just answered, is it true the evidence gathered during your investigation did not establish that the president was involved in the underlying crime related to Russian election interference as stated in Volume 1, page 7?
We found insufficient evidence of the president's culpability.
So that would be a yes.
Without, pardon?
That would be a yes.
Yes.
Thank you. Isn't it true the evidence did not establish that the president or those close to him were involved in the charged Russian computer hacking or active measure conspiracies, or that the president otherwise had unlawful relationships with any Russian official? Volume 2, page 76, correct?
I leave the answer to the our report.
So it is a yes. Is that any true your investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in the election interference activity? Volume 1, page 2, Volume 1, page 173.
Thank you. Yes.
Yes, thank you. Although your report states collusion is not so specific offense, and you said that this morning, or a term of art in federal criminal law, conspiracy is. In the colloquial context, are collusion and conspiracy essentially synonymous terms?
You're going to have to repeat that for me.
Collusion is not a specific offense or a term of art in the federal criminal law. Conspiracy is.
Yes.
In the colloquial context, known public context, collusion and conspiracy are essentially synonymous terms, correct?
No.
If no, on page 180 of volume 1,